Vinay, I think we can start now.
Yeah, sir. I think we should start now because people are still joining in. So I think we'll let them join in and we can start now.
Okay. Mr. Chawla, I'm starting.
Okay. So,
let me just, ladies and gentlemen, a very good afternoon to all of you. And thanks very much for joining our webinar today. Before we start the proceedings, I would request all the participants to please keep your mic on the mute mode so that when the sessions are on, they can go on without disturbances. And during the question and answer session, those of you who may have a question or a point to make, please send them through the chat box option or use the raise hand option. It will help us in taking your queries one by one. Also, the participants are still joining on. Without taking any more time, I would now like to invite Mr. Arun Chawla, Deputy Secretary General of FICCI, for his opening remarks.
Thank you, Dipankar. So, dear panelists, ladies and gentlemen, on behalf of FICCI, I extend a very warm welcome to all of you to this webinar on IP enforcement in India. Changing trends. This interaction is particularly timely when the entire world, as you know, is fighting with COVID-19 pandemic that has not only adversely affected businesses across sectors, but seems to be giving rise to nefarious IP infringement activities, such as online and offline counterfeiting and piracy. While it's a fact that strong IP legislations ensure progress in varied fields and result in the growth of a knowledge bank in a country, it is equally important that the strong IP laws are ably supported by an equally robust enforcement mechanism, because without an effective enforcement system, there can really be no significance to intellectual property rights. India does have well-established statutory, administrative, and judicial framework to safeguard IP rights. However, enforcement of IP rights continue to be a concern, although the government is rightly putting its best efforts to bring in the much-needed improvement to deal with the existing challenges. More recently, India has experienced a number of IP infringement cases, both online and offline, in the past 3 to 4 months, particularly ever since the COVID pandemic worsened in March and April. There has been an increase in counterfeiting cases across products such as apparel, toys, household goods, and accessories. So much so, testing kits and antiviral medicines. This has created an altogether different challenge for enforcement agencies during these unprecedented times. Amazon, meanwhile, has already banned more than 1 million products claiming to protect against a cure, a virus that has no proven mitigation. Similarly, counterfeiters have been caught selling or advertising face masks, lab coats, and infant gas masks on various social media platforms. The Indian IP policy, despite being in compliance with the international standards, has often been alleged to be weak and ineffective by the international community, particularly with regard to protection of patents. Also, India's IP policy has often been targeted by overseas agencies as being ineffective in conforming to global patentability requirements and granting damages upon IP infringement. Despite these, however, there has been a positive development recently, with India's overall ranking improving in the International IP Index for 2020, due mainly to the series of reforms undertaken by the Government of India. Besides other factors like the improved IP administration, several dynamic injunctions by courts, increased penalties for infringements, and the country's efforts at combating piracy. India, with one of the world's largest scientific and technological pools that generate substantial modern-day output, has the potential to be a global leader for IP-based industries. However, without the corresponding IP protection, it may soon become a bane and pose a major hindrance to India's economic development. The Indian film industry, for instance, faces major losses every year due to the unchecked copyright infringement. Thus, it is extremely important that not only our strong IP laws framed, but these are complemented by an equally strong and substantive enforcement mechanism. It will also provide impetus to innovative technologies and financial incentives to IP owners. I take this opportunity to inform you that FICCI, as a voice of Indian industry, has been working very closely with the government on various industry-specific issues through wide-ranging engagements on policy and support services for the business community in particular, through regular interactions and discussions. Last month, FICCI had a very constructive interaction with Dr. O.P. Mishra, Joint Commissioner, Economic Offences, Wing of Delhi Police, on the need for increased surveillance, coordination among law enforcement agencies, and capacity building for police officials to counter the menace of offline and online counterfeiting activities. Earlier also, FICCI, in association with DPIIT, had developed an IPR enforcement toolkit for police to help deal with counterfeiting and piracy. The toolkit is now being used by the state police departments across the country. I must say we are extremely thankful to FICCI's member companies and associates who have regularly provided the guidance and support in carrying out our activities. FICCI, through this webinar today, intends to bring to the fore the key enforcement issues and challenges that India's IP sector is faced with, besides discussing the emerging trends in IP enforcement in India as well as globally. We feel extremely delighted to have with us an eminent panel of speakers from Lexobis, who are also our partners in jointly conducting this webinar today. I'm pleased to welcome Mr. Umesh Puri, partner Lexobis, who heads the trademark design and copyright practice at his firm. Let me also welcome the other panelists, Mr. Varun Sharma, associate partner Lexobis, Ms. Aparajita Nigam, senior associate Lexobis. I welcome these distinguished speakers once again and thank them for joining us today. Before I end, I would also like to thank all the participants for taking out the time to attend this important webinar and look forward to an informative, interactive session today. May I now invite Mr. Umesh Puri, partner Lexobis, to take us through the first session. Thank you. Mr. Puri.
Yeah, thank you, Mr. Chawla. And good afternoon, everyone. Thanks to FICCI for organizing this webinar on IP enforcement. First of all, during this pandemic, I wish everyone is healthy, and I also wish speedy recovery to all those who have tested positive. I know these are very challenging times for all of us. Am I audible, Dipankar?
Yes,
Yes,
you
yes.
are. Yeah. Very much.
And these are very challenging time for all of us, being IP practitioners, being the IP owner, as well as whoever is doing business. It's very challenging time for all of us, and hopefully this will be over soon. So coming to the topic, I have a presentation with me. I'll just open that as well this way. Is this presentation visible, Dipankar?
Yes, it is. Yes, please.
Okay. coming to the topic is trademark enforcement. So most of us are aware that protection is paramount. That's why we register our brand, our work, our invention as trademark, copyright, designs, patents. But we also need to understand that enforcement is equally important. We need to use those IP certificates to enforce our rights. Today, there are two main markets where the brand owners are currently facing counterfeit and as well as infringement issues. Of course, the first one is physical market and second one is online market. So online market has become more relevant during this unprecedented times and for times to come. If I can share my own experience in the last 3 months, I have bought everything online except medicine. So everything you can now buy online. So there was one survey a few years back that whatever growth we are having in online market, it is going to be 5 times of what we had in 2027 by 2026. But during looking at this current pandemic, I believe that we are likely to reach that figure very fast. So when we are talking about online enforcement, the brand owners they don't only have to restrict themselves to only online market, because there is a very strong connection between online market and physical market. The counterfeit products which are available for sale on online market, they are being manufactured somewhere. So it's very important that we need to find out the source of the manufacturing entity and target that entity as well. When we talk about the trademark enforcement, we have both civil as well as criminal remedies. Now, unlike like in trademarks and copyright, we have both civil and criminal remedies, while in patents and designs, we have only civil remedies as well as some administrative remedies we have. Now, when to go for civil remedies and criminal remedies, it depends upon a lot of factors. Like wherever the defendant is established, it is known, they have a permanent address, they have a private limited company or a public limited company. Whenever there is a question of this deceptive similarity between two marks, or where there is a combination of colors are involved or lookalike features are involved between two trademarks, or in cases where there is a use of a corporate name by other party on some packaging or in their own trading name, then in all such cases, going to the court and seeking injunction and damages are advisable. So civil remedies would be better option in all such cases. Why so? Because when you file a suit for infringement or passing off, you can seek interim injunctions also. That can be given to you within 2-3 days of filing the suit. Sometimes ex parte also. So in all such cases, civil remedies are advisable. Criminal remedies are also equally effective when the purpose is to raid and seize the goods and you want to arrest the counterfeiter. In all such cases, criminal remedies can also play a very vital role in combating counterfeit activities. There are certain markets which are I should say that infamous for certain activities, counterfeit activities in a lot of cities. So in those cases, we are aware of that as an enforcement agencies as well as a IP practitioners. We are aware of all those notorious markets. So in all such, so since there are so many players dealing with counterfeit activities in those markets, it's better to have a general impact of conducting a raid and seize the goods. It may not be possible to only take action against a particular person by going to a civil route. It would be better to arrest someone, give them a sense of feeling that the brand owners are worried about such counterfeit activities and they are going to take action against whoever comes in before them. So in all such circumstances, criminal remedies can be an effective remedy. Now, whenever the brand owners need to take any action against a particular person, then we need to decide that, okay, what would be the cost of taking action, whether the local enforcement agency in that particular area would be supportive or not. If you're going for a civil remedy, whether the judges who are there in that place, will they understand the nuances of IP laws? So in all such cases, all these points need to be considered while making any IP strategy. Now, there are a lot of other things which the brand owners need to consider. Some of them are there on the slide, so I would just touch upon some of them. You need to have a good investigation team. As I mentioned before, that the purpose of investigation is to find out the source of a manufacturing. I can understand that at some times it's not possible. Then in those cases, we might have to go to wholesaler or a retailer. But at least you need to make sure that the investigation team is able to find out the source, the actual source where the counterfeit products are being made. You need to have a good knowledge about the place where you want to conduct a raid. That place should be approachable. It should not be the case that you reach there and it's so difficult to come out from that place. So that should not be there. The law enforcement agency their time should be there, like they are made available during this time. So all those points we need to consider. You need to have a good relationship with local enforcement. So there are so many parties involved when you want to take action against counterfeiters. The law firms you have engaged, the lawyers you have engaged, the investigation agencies, as well as the brand owners, along with the local enforcement agencies. So all these need to have a very cohesive and very coordinated approach in conducting raids. There are a lot of anti-counterfeit technologies which are available nowadays. So, and during this pandemic, what I believe that most of the brand owners should go for anti-counterfeit technologies like QR code authentication using smartphone, Neurotex, RFID, and I know that most of the brands are adopting such technologies, but I believe that a lot needs to be done in this respect. This is an opportunity for all of us to have as many technologies we can adopt during this pandemic time. It will help in future also. So, as I said earlier, that the law enforcement agencies must be regularly updated on any increased changes or development in counterfeit activity. So, as there is a very strong requirement of a proper coordination, if that is the case, then the local information, the police authorities, they should be updated if there is an increase in counterfeit activities, or there's some very particular place which is coming up with a lot of counterfeit products. So all this should be informed to law enforcement agencies. The brands, they also need to create a lot of awareness campaigns amongst consumers, which means that they need to tell their consumers as well as customers that how to differentiate between a genuine product and a counterfeit product. This would resolve a lot of things. I know that there are a lot of brands we already working on this, but I think there is a lot to be done, because in some of the cases where our clients, when we tell them that, okay, this is the problem, this is a counterfeit product, so they generally ask that, so how to differentiate? So I think there is a lot more scope which to be done in this respect. Ample availability of a genuine products at affordable prices. So this is also very important. If you can make your products available at very affordable prices, the counterfeiters will have a lesser chance to copy your products. So these are some of the points which should be taken against counterfeiters. Now, in the criminal enforcement, there are a lot of challenges. So right now we can divide these challenges into two parts. One is the legal challenges, and other one is the administrative challenges. Now, the Act, our Trademark Act, mandates that the police officer not below the rank of DSP level should be taking any cognizance of the complaint which is solely made on trademark falsification or trademark infringement. So as you can see that, or as you might be knowing that most of the senior police officials, they would be busy in other criminal activities, handling other criminal activities, if that is the case, they may not give as much importance to counterfeit activities. So that's one of the hurdle which we have to tackle while going for a criminal enforcement. Then there is another registrar opinion. So even if you're able to find out that, okay, there's a police officer who's going to take action against counterfeit, if you're solely relying on Trademark Act, then you need to go to Registrar of Trademarks and take an opinion. So this would delay the whole process. So that's why most of the criminal enforcement is being done along with other statutory laws, like Copyright Act is there. Then we have IPC is there. So if you're totally relying on the Trademarks Act, it may not be very effective because of these two problematic features. Like in copyright, the sub-inspector level can take an action. Similarly, in registrar of trademark opinion, you're taking an opinion from registrar of trademarks, maybe a little cumbersome. So enforcement agencies not giving importance to counterfeit problems. They might be busy in something else. So in that case, like we have, when we talk about the civil remedies, like if we talk about some specific courts, they are they understand the IP very well. Similarly, the police authorities in some specific states have been given much importance, have been given the thorough knowledge about IPR violation, but that may not be the case with every state police. There are a lot of things which are going on to make them understand that the enforcement agency, they should give proper importance to counterfeit problems. So there are a lot of things which are going on, but I still believe that at this point of time, when there is no such consistency amongst all the enforcement agencies. If you really want to eradicate the counterfeit problems, I would suggest that there should be a specific IP cell in each district of police station. So that would be the ideal way of handling the criminal enforcement. Similarly, in case of excuse me, hello. I think the slides.
The slide not visible. Not visible, sir.
Not visible. Just wait. Just wait. Is it there?
Not yet.
No, sir. No, sir.
Vinay, can you open?
Just Umesh, just try this. I've just given you rights again. Just try and see.
Yeah, it's come.
Yeah.
Yeah, it's there.
Yeah.
So similarly, in civil enforcement, there are a lot of things the brand owner should know. The first and foremost thing is the interim injunction. In most of the hello, I think again slides have.
No, but we are able to view this, Umesh. It's on screen.
Just wait, I'll just open it again. Now, is it visible? Yeah, I can see right now. So interim injunction plays a very important role in any IP infringement suit. So especially in trademark cases, if you are able to obtain interim injunction, that would resolve a lot of things. So in any trademark litigation, the primary purpose has always been to obtain the interim injunction, because once you get the interim injunction, in some cases you can also get the ex parte injunction. But if you're able to get interim injunction, that would resolve a bigger cost in trademark litigation. Because most of the times the defendants, they do not appear. If they do appear, they settle the matter. So that's why interim injunction is very important. Similarly, in summary judgments, in the recent past, there have been few cases where the courts have been granting summary judgment. So summary judgment, whenever the court believes that the plaintiff or defendant, they do not have a very good case on merits. So the court believes that there is no need to go for trial. In such cases, the summary judgment can be passed, permanently injuncting the defendant to stop the use of the mark. So in those cases, the ex parte evidence are not required to be led. So it plays a very important role. The damages, the courts, it all started with times judgment. Now it started with 5 lakh rupees. Now you look at the court orders. Delhi High Court, from Delhi High Court in Watman case, we have damages going up till 3.85 crore rupees. And in Nippon case from Bombay High Court, we have damages going up to 5 crore rupees. So that has been a very effective deterrent against counterfeit and habitual infringers. So there is a less time in trial after Commercial Courts Act. After the enactment of this data, I think, yeah. Hello? Sorry, it has again gone, I think, somewhere. I'll just open this. Yeah. So after the enactment of Commercial Courts Act, the period for trial has been reduced significantly. In some of the cases, you can have a final verdict from the court in 2 to 3 years' time, sometimes less than that also. The cross-border reputation. So I would like to touch upon the Trias case. There has been a feeling amongst brand owners that this argument may not sustain after the Trias judgment. As a practitioner, I can assure you that the Indian jurisprudence totally accept the argument of cross-border reputation. The brand owners, they need to, especially the foreign brand owners, they need to have 2 things in their mind. One is the cutoff date, and the second is the evidence which they need to lay. Now, what would be the cutoff date? The cutoff date would be the date when the defendant started using its mark. So if that should be the date for the purpose of saying that you have earned a transporter reputation in India, that cutoff date, you need to lead evidence before that particular date to establish the international goodwill and reputation has crossed border and reached India. So that is the point of factor which I think the foreign brand owners need to consider, that they need to lead sufficient evidence. The prior judgment was a result of, I think, a lack of sufficient evidence. If we keep these 2 things in our mind and lead sufficient evidence, I think the foreign brand owners would be able to assert their rights in India only on the basis of transporter reputation. So John Doe orders, this has also been very popular, especially in the copyright industry. But if you look at some of the recent trends, the courts have issued John Doe orders against identical trademarks. What I believe that it should be restricted to identical trademarks with respect to certain goods and services, because it cannot be a case of deceptive similarity, because the local commissioner who would be appointed in such cases, they may not be able to decide that what is a deceptive similarity in such cases. Threshold for trademark confusion with regard to medicines and pharmaceuticals is low. There has been a recent trend amongst the medical fraternity, especially in the cases where the 2 drugs names are similar, but they have a different purpose. Even in those cases, the courts have said that they have given injunction against the defendant. Reason being that it can have a severe effect on the health of patient. These are some of the trends. There are others also. Because of the time constraint, I may not be able to cover everything. But I would, the whole purpose of giving this was to, educate. We can discuss further during our question answer round also. Now, I would also like to touch upon the issues which we all are facing on e-commerce platform. What has been Hello? Yeah, now it's clear. Sorry. Court's take on liability of intermediary. So, what is the situation on the e-commerce platform? If we talk about established e-commerce platform like Amazon or Flipkart, they have a very robust system of takedown notices. Like if you come across any counterfeit products, you tell Amazon or Flipkart or any e-commerce platform, being an intermediary, they need to take action against that infringing link. Yeah, so it all started with MySpace judgment in 2008. So this suit was filed in 2008, but in the initial stage, the injunction was granted, but subsequently it went before the division bench. The appeal went before the division bench, where it was said that the intermediaries are not required to know everything, whatever is happening on their website. It's the rights holders' duty to inform intermediary that okay, this is a particular link where there is infringing activity going on. If they follow that practice, then of course the notice and takedown procedures would be taken by all those e-commerce platform and intermediary. Similarly, as soon as like the duty of intermediary is to be a passive player between buyers and sellers. As if they start acting as an active player, then they can be held responsible. In the recent past, there has been an increase of litigation between e-commerce platform and the brand owners. So we need to look for a balance between them. The balance is that the e-commerce platform should only remain as a platform where the buyers and sellers can meet and make their own transaction. As soon as they become more than intermediary, they can be held liable, as it was held in Christian Louboutin case. In this case, the website which was selling Christian Louboutin products, they claim that they are 100% authenticated products. They are all available on their website. So that may not be the correct statement. If that is not the correct statement, and people are going on those websites and buying stuff from that website, then that particular website can be held liable. The court made it very clear that when an e-commerce platform becomes an active participant as opposed to merely being an intermediary, then it would automatically lose safe harbor protection. I would also like to discuss one of the very important case in the recent time, which is MV case. Now, there are so many facts which were involved in this case. I would only restrict myself to the trademark issue. There were direct selling guidelines. There was a tortious inference. I would not like to touch upon. So in this case, what happened that, as you might know, that Amway or Modi Care, they make their sales through direct sellers. So they cannot just sell, their products are not available on the market as such, but all these direct sellers, they filed case against all the e-commerce companies, claiming that they were selling the genuine products. They were all genuine products of Amway or Modi Care. But there was an issue on them that first it's a violation of direct selling guidelines. I would not like to touch upon, but when it came to the product asset, the local commissioner was appointed in that particular case, and it was found that inner seal of the products were broken, QR codes were removed, and resealing of products were done. New barcodes were fixed, all under the control and supervision of defendant e-commerce companies. So due to this, there were negative reviews which caused damage to the reputation and goodwill of the plaintiff. This was the finding of the single judge bench. It was said that even differences in services and warranties, advertising and promotional efforts, packaging, quality control, pricing, and presentation would amount to impairment of the product. Whenever there is an impairment of a product, in that case, the e-commerce websites can be held liable and injunction. However, this particular decision of the single judge was set aside. Hello? Yeah. It was noted by the division bench the question as to whether the goods were in fact tampered with could only be settled by examining evidence. So this was the issue which the division bench said that it can be tried after the trial. It can be examined. So the evidence need to be led to the effect that goods were actually tampered. Accordingly, the decision of the single judge was set aside. However, I think that the matter has reached to Supreme Court. There is a evolving judicial principles which are governing right now the whole online enforcement on e-commerce platform. This is what I just wanted to cover. I think I would like to have more interactive session. If I missed anything on on any of the issues which the brand owners are currently facing.
Well, Mr. Puri, thank you so much for the very informative address on the issues and challenges in enforcing trademarks in India, as well as changes being witnessed in this area. I'd also like to inform that for the benefit of the participants, that Mr. Puri, besides heading the trademark design and copyright practice in Lex Orbis, has extensive experience in prosecution and enforcement of IPRs, advising clients on complex commercial and IP transactions, particularly in the field of technology and media and entertainment sectors, among others. He also advises startups and MSMEs in identifying and protecting their IP assets, besides being associated with IP awareness campaigns by the government. We now come to the question and answer session. I do not see any question or remark in the chat box. If there is anyone wanting to ask a question, kindly come in and raise your question, please. Well, I don't see anyone. Umesh, is there anything you wanted to add to what you said, or explain some recent development, or before we move on to the next session?
Hello, can I ask a question?
Yeah, please mention your name and then put up your question, please.
Yeah, I'm Dr. Anushri Gupta. I am also an IPR practitioner. But what is your stand on the enforcement in the area of patents? Trademark and copyright has been quite well known and people are working on it and people are aware. But how much is the awareness and enforcement issue in the area of patents?
Like patents, there is another presentation which is going to come up for patents specifically. But I would like to address, like in patents, we have enforcement only through civil route. Means that you have to go to the court and seek injunction from the court. It could be interim injunction or permanent injunction, as well as damages. So the enforcement, when we talk about patent, it could be only civil remedy, which would be to going to the court and asking for injunction and damages.
Yeah, of course. We know about that and very well aware. My intent of the question presently was with the situation what we are undergoing for COVID-19. Any kind of cases or any examples have you come across during this time to just report to us? The intent of the question was that.
Absolutely, Anushri. So right now, if you have any urgent matter, even the regular hearings have also started before Delhi High Court and any other courts of India. If you have any urgent interim application, you can file a suit before Delhi High Court, any another court. The hearings are being conducted very regularly before the court, and the courts are granting interim injunction as well as permanent injunction. So it's not the case that during this current pandemic, of course there are challenges because of the limited functioning of courts. But if you are able to make out your case of patent infringement, you have the remedy right now going to the court, and you can seek injunction from the court. That's very much available at this stage of time also.
Okay, thanks for the information. But my question was focused on whether there is any related to any invention related to COVID-19 coronavirus inventions, any infringements or any cases have come up which you are aware of?
No, right now, actually, there is no medicine for this, as you know. So there would not be any patents.
But there are related inventions which are, of course, not a direct drug on COVID, which has been on clinical trials. But there are, drugs which are repurposed drugs and are being utilized for this purpose. And is there any issues like Gilead case, of course, everybody is aware of, which is going on, and already, license have been issued. So there any other case where similar kind of work is come up or you are aware of in this area?
As far as Indian case laws are concerned, I have not come across. I'm not aware of. But my other colleague who would be taking a session on patents, he would be better equipped to answer this question. So I think Varun is there. So maybe after his session,
yeah, no, I know Varun. I can interact with him. Thank you. And any other enforcement issue with respect to the Plant Variety Act?
That also Varun would be taking.
Okay, right. Thank you so much for taking the questions. I'll put up these questions to Varun.
Yeah, sure.
Thank you, Ms. We also have another question now from Arnab. And what he asks is, what basic steps can brands and companies take themselves to safeguard their IP rights, especially in trademark and copyright, before going the enforcement route?
Yeah. So as a brand owner or as any IP owner, as I mentioned before, you have both civil and criminal remedies. And so in those cases, you may have to go to the civil court and, or local enforcement agencies to enforce your right. But before that, if someone is infringing your right, then in that case, you can send them a, legal notice. It depends upon a lot of factors, whether that person would be complying with your request or demands or not. But depending upon the facts and circumstances of that particular case, you can issue a cease and desist notice. I have experienced myself that at times the infringers or copyright, sometimes there is no mens rea in copying some certain contents. They might not be aware of that they are infringing someone else. Hello. So, hello. Am I audible?
Yeah, you are. Please go on.
So in that case, what you can do that you can send them a legal notice in-house before going to the court and before taking any other action against legally available action. So all such things can be explored. You can have a chat with him, that particular person who's infringing, whether he knows that he's infringing someone else's right or not, or sometimes if you even after receiving a notice, some of the infringers, they say that, okay, we were not aware of, we are, from my personal experience, I can say that I have resolved a lot of conflicts through, by issuing a cease and desist notice, by talking to the infringers or a counterfeiter. So it can be done.
Right. Another question has come up. It's from Khyati Almani. She asks, Trademark Act has been a challenge faced by every IP lawyer, and one needs to take resort to copyright provisions. is there better alternatives to expedite favorable outcomes?
So I hope that this question is related to criminal enforcement, and I agree with the the question which has been asked. So as a brand owner, you need to take help of other statutes like IPC and a Copyright Act. But there is a, I don't know how many of you are aware that there has been a talk going on for amendment of our IP laws. So if, and in that, Lex Orbis is one of the, participant, and we have been requesting the ministry to, change the Trademarks Act, especially when it comes to the criminal enforcement. It should be, self-made act. It should be self-standing act, which would act against counterfeiters. That has been the purpose, and I totally agree with the question that right now we have this difficulty, but in future there is a very good news is on the way, I believe. I think the ministry, DPIT, is gonna have a look at all the recommendation the Lex Orbis has made on behalf of all the brand owners, that the relaxation and the amendments which we are seeking in, especially in section 115 of the Act, would help the situation better in the coming future.
Right. Thank you. There's one more question. This is from Siddharth Pandey. Whether civil remedies are better alternatives when compared to criminal remedies for better brand protection?
I would agree to a certain extent, but as I mentioned before, there are some markets, there are some places where you would not be able to enforce through civil remedies. So in those cases, you may have to go for criminal remedies. But in most of the cases in trademark litigation, if you'll see, the better is always to go for a civil litigation if it is at all possible. Wherever it is not possible, then of course you might have to go for criminal remedies, because as I mentioned in my presentation also, that there are certain advantages for criminal enforcement as well, up to which will target a specific market or specific area which is infamous for counterfeit activities. In those cases, I think criminal remedy would be better, but it depends upon the facts. So if you have a product which is which is being manufactured, the counterfeit of which is manufactured heavily, then in that cases it may not be possible to go and ask for a specific injunction. Now there is another way which you have to look. There is a tendency of getting a John Doe kind of an injunction for trademarks. If you're able to obtain that, that would also serve the same purpose what is going to be served under the criminal enforcement. So it all comes down to that: what is your product, who is your infringer, what's your target area. So there are a lot of things which you need to consider while going for civil or criminal enforcement. But I would recommend that civil enforcement may be a little better approach.
Well, there are quite a few questions coming in, but we are running short of time. I'll just take one more. This is from Shubho. One second. Shubho Bhattacharya. Can the evidence of a favorable outcome of a criminal case read as evidence for civil case? Yeah, so the thing is that it would be specific to one particular counterfeit. In the evidence, so there are two different actually actions under civil law as well as criminal law. So in the criminal, you're saying that you have obtained a favorable order in criminal against a particular counterfeit. Whether it is, if it is a counterfeit, then of course it may help you in getting some kind of a relief from the civil court also. But if it is a question of deceptive similarity, then I may not. First of all, it would be difficult to get in some kind of a relief from criminal court
when we talk about deceptive similarity, because there are a lot of issues which are involved in criminal enforcement as well. But if it is against counterfeit, the facts are same, then of course you can use order which you have obtained from criminal proceeding in civil cases as well. It will have a very persuasive value. There is no doubt about it.
Right. There's also a question on copyright, which I'll ask. The asker is Mr. Kumar to ask in the last session, which is on copyrights. And one quick question again on trademark. I'm going to make this the last one. What are the criteria or requirements for obtaining John Doe order in trademark infringement?
So John Doe injunction is kind of an interim injunction only. First of all, you need to meet all those three criteria of interim injunction application: the prima facie case, balance of convenience, and that there will be irreparable damage would be caused to you if you are not given injunction. Now, there are two more things which you need to establish in John Doe injunction. First is that you need to establish before the court that there is so much of a rampant infringement or a counterfeit activities that it's next to impossible for me to go against each and every infringer or counterfeiter. That's a additional requirement which you have to establish. Along with that, these parties who are counterfeiting my product, they are unidentified. I cannot go against them. So they are unknown parties. There are so many that I cannot plead them in my civil suit. So these are the two additional things which you need to establish before the court while going for John Doe injunction for trademarks. Apart from the three main requirement of interim injunction.
Right, Ramesh. Thank you so much. I'm not going to take any more questions in this session because we are completely out of time. Thank you, Mr. Puri. I think that was an excellent, interactive, and your presentation as well was great. We will now move on to session 2 of the day, which is on enforcement of patents and designs in India and the key challenges. The focus here will be on the key enforcement issues in patents and designs in India and the emerging trends that we see in this area. To speak on this theme, may I welcome Mr. Varun Sharma, Associate Partner, Lesorbis. He is an engineer. I'll also quickly just introduce him. He is an engineer and lawyer by qualification. His work includes appearing before various courts of law, including high courts, district courts, IPAB, and other tribunals and adjudicatory bodies. He has extensive experience in IP drafting, filing, prosecution, and in appearing before controllers and examiners, the IP officers, especially in patent matters. He has also worked on prosecution, patents, applications for the USPTO and European Patent Office. Mr. Sharma, we are delighted to have you. You may like to make your presentation. Thank you.
Thank you. Good afternoon, ladies and gentlemen, and thank you, FICCI, for organizing this. I would waste no time now, and I'll start with the presentation. Yeah. Is everyone able to see the presentation?
Yes, Mr. Sharma, we can see it.
Yeah. So India is right now not just a lucrative market, but it has become a dynamic hotbed of intellectual property rights in recent years. And these cases, enforcement cases and IP, particularly patents, has picked up in the last decade or so, I would say since 2007. And although these patent matters is quite recent, but the legal principles have already been forged long ago. To cite one example, there was a case in 1934, Lalu Bhai versus Shyama Das, in which the injunction was granted first, and from that time till now, Indian courts have always reinforce the importance of protecting intellectual property rights. So the trends
Yeah.
here in India actually concur with the worldwide trends, although the volume of patent litigation in India is not that
Yeah.
high.
Varun, your presentation is not visible.
I see.
Yeah, now it is fine. Yeah.
Is it there now?
Yeah, now it's fine. Please go
Okay.
on.
Yeah. So I would start with my first slide. So this is a comparison between patent and design cases versus trademark and copyright cases, particularly the difference in law. So as Mr. Umesh had already said, that in patents and designs we only have civil remedies by way of a suit for infringement. Whereas in trademarks and copyrights, yes, there is an option to go for criminal enforcement. And another difference is that when a right holder sends a cease and desist notice or repeatedly sends such notices, the respondent has the option to file a suit for groundless threat. So in trademark, what happens is if such a suit is filed by the respondent uh, and the right holder eventually files the trademark infringement case, so the earlier suit for groundless threat ceases. But this is not the case in patents, and there is no provision that it will automatically cease if a suit for infringement of patent is filed, um, while a suit for groundless threat is pending. And another difference is like patent rights have now been excluded from the purview of scrutiny of custom authorities since 2018 by notification. So these are small points of differences between these two laws. And this is it's a synopsis of the changing trends that we have foreseen recently in patent and design enforcement matters. One is the enactment of Commercial Codes Act. Another is new High Court rules, especially Delhi High Court rules, which are quite conducive now to patent and trademark matters. Another is an increase in the uh, infringement cases relating to standard essential patents, as well as increase in pharmaceutical sector. Another, so commercial courts and new high court rules, they apply to both patent and design cases, while SCPs and pharmaceutical sector litigations are more focused on patents. And another trend that is now prevalent is that designs, and in fact, even trademark cases are now being filed in tier 2 cities, in other cities. Otherwise, Delhi High Court has always been the hub of litigation, IP litigation in India, and followed by Bombay High Court and Madras High Court. And in fact, Delhi High Court has helped shape patent law in India more or less, and its judgments are not only noticed by other high courts but other international forums as well. And the recent judgments, in fact, especially those rendered after trial, have clearly established India as a strong enforcer of intellectual property regime. So we start with the Commercial Courts Act now. So there have been many amendments and new introductions now, especially in the procedural aspect of litigation. And I'm just covering the three most important ones. First is the case management hearing. So normally a lot of delay used to occur in cases because of the procedural delays. The trial used to take time, the examination and chief examination of the witnesses, and there were a lot of unnecessary adjournments on one pretext or another, which used to cause a lot of delay. But now with this option, what happens is that when the trial begins, right at the commencement of it, the court hears the party and on mutually agreeable terms decide a schedule for the trial. Like how many witnesses are there, how much time each witness is going to take in examination, and how much the other party is going to take for the cross-examination of witnesses. And this way, the procedure, at least it makes it more predictable when the trial is going to get over. And next part is the summary procedure. I think Mahesh has already discussed this. So where the Commercial Codes Act 2015 has introduced Order 13, which says that in cases where oral evidence is not required, or it is not that important, not necessary, and there is no need to go for elaborate evidence procedures, then in those cases, a summary judgment can be passed at the request of any of the party, either on the entire suit or in one or two issues that require no oral evidence or helps. This is more important when the documents are admitted by either of the parties and they need not be proved. They need not be summoned from the records of the other authorities. So that takes a lot of time in summoning witnesses, especially formal witnesses. And where the documents are admitted, then in those cases, or where there are public documents which are not refuted, this is important, summary judgment, and it reduces a lot of time. There has been a case where a summary judgment was passed, but the appellate court found that that particular case required an elaborate trial, so it was set aside. But eventually, it has paved way for reducing a lot of volume of cases, and the delay that normally happens during the trial process. Another significant reform has been introduction of mandatory pre-institution mediation, and where there is no urgent relief that is sought. So in cases where the plaintiff, the right holder, does not have any urgent relief required, then they can start with pre-mediation. They have to do it mandatorily, the pre-institution mediation, and this has helped reduce the volume a lot. And most of the cases, not most, but a few of the cases are settled in mediation. But this stat is true more for other commercial cases that involve transaction of money, loan, etc. In IP cases, since urgent relief is sought for every case, this particular reform has not been very useful. As on October 2018, the trend is like 63% cases were disposed by High Court of Delhi in less than 1 year, and only 17% continued for more than 2 years. And 45% of commercial cases were settled, and only 34 of them were adjudicated by the court. Rest might have been withdrawn. So this shows a very positive trend that most of the cases are disposed of quite early, in less than 1 year. One of the reasons for that is that in IP matters, especially patents and designs, what happens is the injunction plays a very vital role. The interim or ex parte injunction plays a very vital role in these cases. So if an injunction is granted and most of the infringement is admitted or prima facie accepted, then normally the party settles. Or in other cases, what happens is it's mostly the dispute of royalty, and those are negotiated and settled. So that's why 63% cases in High Court have been settled, have been disposed in 1 year, and 45% of them were settled. So this is a very positive outcome of commercial courts. And to list few of the advantages, the case management hearing makes the length of trial predictable to a great extent, apart from few adjournments that every lawyer seeks, and force of habit maybe. But the thing is that some are unforeseen adjournments. Apart from that, the length of trial does become very predictable, and courts on their part fix very short timelines for each stage, and that reduces the period of trial. So there is no laxity that you have to take like 2 months to cover a witness, but the court fixes continuous hearings to have the evidence completed quickly. The second is the summary option helps in cutting down the time spent in elaborate evidence procedures. As I told, this is important where most of the documentary evidence is admitted by the other party and recording of evidence, rather elaborate evidence, is not required. Pre-institution mediation also helps in preventing long-drawn trials, especially where urgent reliefs are not sought. This has been made mandatory, and it has helped in reducing the volume of cases that normally clogs court businesses. Uh, Apart from these three measures, Commercial Courts Act also made changes to Civil Procedure Code, and the timelines, especially during the pleading procedure when the suit is filed and the reply written statement has to be filed and a replication to it, rejoinders, uh, documentary evidence, all these admission denial affidavits, etc. So these strict timelines have been given for this. For example, for WS, written statement that a defendant has to file, the time is only 30 days, which can be extended to an outer limit of 120 days. And beyond 120 days, the defense is inevitably struck off. There is no Supreme Court has recently held there is no way the defense time can be granted beyond 120 days for filing a written statement. And even within those 30 days and 120 days, it's not the right of the defendant to file the written statement anytime. He has to move it with the help of an application for condoning the delay, and the courts might impose costs while allowing such a request. So with stricter timelines, the historical delay that used to happen in procedure has been reduced quite significantly right now. Apart from commercial court, Delhi High Court has taken a lot of initiatives now in easing, making it conducive for patent and design cases. As we might conquer that a patent infringement case not only involves a question of law, but also complex technical questions of fact that are important to be determined for a proper and just adjudication. A technical expert is an indispensable part of any patent litigation, although the bench hearing the case might not be an expert in that field. So there are options of scientific advisors also, but technical experts are still a very indispensable part. And normally it takes a lot of time to examine, cross-examine these technical witnesses. Particularly, first, the plaintiff technical witness would come depending on the burden of proof, or the defendant's technical person will come. He will be examined, he will be cross-examined, then the other party's technical person would be examined and cross-examined, and this would take a long time. So, and these cases obviously pivot a lot on the technical issues. So to reduce that time, the Delhi High Court has introduced this concept of hot tubbing. It was started by the Australian courts first. So by which Rule 6 was substituted in the Delhi High Court original site rules, in which what happens is expert witnesses of both sides, they make a list of the technical issues on which they agree upon. And they also make a list of technical issues which they disagree upon. So the points of disagreement are then brought before the court and heard by the court simultaneously, in the sense that both the experts are present at the same time before the judge and the opposite counsels, and the judge as well as the opposite counsels are caution those technical experts on those point of differences simultaneously. So this way what happens is that the time taken in elaborate cross-examinations stage by stage is significantly reduced. So the technical issues are sorted in a much lesser time. Another aspect is the confidentiality club that has been introduced by Rule 17. And although the rules have been framed, but the rules also give leverage to the court hearing the matter to make specific arrangements for how the constitutionality club would be constituted, or how the proceedings in that will be constituted. Normally what happens is that the court records which are filed under sealed covers, being confidential information, are revealed only to the counsel of the parties, one counsel and one assistant counsel, and in-house counsels are not allowed, and they can prepare their notes or they prepare their case by looking at those documents in the court premises itself, and then those documents and that information is again sealed back and it remains with the court. So this way there is a balance that the other party should not be surprised by what the case of the other party is. So these documents are actually revealed, but also those are maintained under confidentiality, so that the other in-house counsel, the other party is not privy to what the confidential information is. Now, with the recent COVID scenario, pandemic, there was an opportunity in disguise. All the video conferencing was going on before as well for recordal of evidence. But with this pandemic, with this situation, though unfortunate, the courts are now taking up urgent matters on regular basis through video conferencing. So this is a very important tool that has been introduced now, and I believe it would set a new norm now, especially Delhi High Court and other high courts, to have particularly IP matters done through video conferencing. Most importantly, because the witnesses, the technical witnesses, the parties are normally located far off from the jurisdiction of the court that is handling the matter. Mostly, some are located outside India. And so hearing in cases would be much easier now through video conferencing. In fact, every day, I mean, the entire bench is now functional for urgent matters only, though, but quite regularly through video conferencing. So the registrar is approached, and the grounds of urgency are told to the registrar, I mean, in writing. And then if the registrar finds that there is, yes, a ground for urgency made out, he shares a link and the hearing can be conducted. The documents can be filed online. And in case the registrar does not find that the case requires an urgent hearing, then yes, a single judge is appointed for determining whether there is any urgency or not. And if the finding of the registrar is reversed and the court finds that no, it required an urgent hearing, then the entire process starts of filing pleadings and hearing the matter on video conferencing. So on June 13th, 2020, High Court of Delhi has also introduced an online e-filing platform for all the pending cases and the urgent cases as well. So now the filing of cases is quite easy, and it is very helpful, especially because patent and design matters, they have a lot of volume of documents. They are like huge volumes that have to be filed. And now with this facility, the litigants can easily file it, the lawyers, from the comforts of their offices. And it is very helpful. In fact, recently during these COVID times, the High Court of Delhi has even exempted affidavits to be attested. And pleadings can be filed without even attestation of the documents. This is the new norm, perhaps. And the best part is that the video conferencing rules have been now enacted by the Delhi High Court, and it has opened up for all stages of judicial proceedings, hearings, recordal of evidence, and even final arguments are now these days being made through video conferencing. Now, we come to the next one. So recently, I mean, last decade or so, there has been a manifold increase in patent cases, especially enforcement of standard essential patents. So what is an SEP? I'll just breeze through these important aspects. So when a patent in a particular technical field, let's say mobile telephony or Wi-Fi, becomes necessary to meet a standard, like in the IEEE standards we have in Wi-Fi and mobile communications. So if there is a patent and there is a standard, and the patent reads onto that patent becomes the standard essential patent. So in a way, if somebody is following that standard, if somebody is implementing that standard, that person is inevitably using the patent. That is the purport of a standard essential patent. And how it is qualified, how does a patent qualifies is that they associate their patents with some standard setting bodies like IEEE and GSM, and then these bodies analyze and they include it in the standards. They find it, and but the most important part is that if a patent holder is associating their patent, its patent to a standard, he has to mandatorily agree that that he would license that patent which has been read onto the standard in a very fair, reasonable, and non-discriminatory terms. We call them FRAN terms. So there cannot be they cannot charge something different or high from one and low from another. There are like various examples, and in fact, this thing has not found any judicial scrutiny as of now in India. But these are broadly this is broadly the concept on FRAN terms. Once the patent owner agrees to that and the patent becomes necessary to meet a standard, it qualifies as SEP. But why? Why do patent holders associate their patents to a standard setting body or make it a SEP? Is first that, as I explained, it would be inevitable for any manufacturer of device on that standard to use that patent. So license becomes mandatory on part of the manufacturer. On the other hand, patentee holder would offer that on FRAN terms. The second important thing, especially relating to patent litigation cases, is that if a patent is prima facie established as a standard essential patent, then there is a presumption of infringement. If the the infringer's device meets that standard, implements that standard, then there is a presumption of infringement. So in that scenario, if this part is established that the defendant is using that standard, the device is using that standard, and that patent is a standard essential patent, or it is an admitted fact between the parties, then the parties can utilize the summary judgment procedure that is available. That in this case, elaborate discussion of evidence, elaborate evidence is not required, and so it is very helpful. And even in interim injunctions, if it is so prima facie established that the manufactured device is implementing a standard and the patent is reading upon that center, it's a standard essential patent, then interim injunctions are more or less right to be granted, assuming that there is an infringement. And there have been a lot of cases now. I'll take the important ones. One is the Philips case of DVD players, and this case has a reputation of being the first judgment on an SEP after full trial. Although it was based on SEP, but unfortunately the courts were not did not have that opportunity to discuss what are FRAN terms or judicially scrutinize the FRAN terms. But the trend that has been seen of late in SEP cases is, especially at the interim injunction stage, is that the courts rely upon what are the conditions or royalty payments agreed upon by the patent holder with other device manufacturers. So normally the courts sought those licenses under confidentiality and look upon what has been the general trend of giving license, and based on that, some interim arrangement is being made in SEP cases. Similarly, in Philips case, in the final judgment itself, the bases were more or less on this line, and at least USD 5.3 million is expected in damages to be calculated by a commission. So the court gave a verdict that there has been an infringement and there were punitive damages. Apart from that, a local commissioner was appointed to render the accounts of the defendants to find out how much sales they have made, how much loss has occurred to the patentee, and this is the figure that is expected right now. Similarly, there were some Ericsson cases filed against mobile manufacturers in India in relation to their 8 SEPs on mobile standards. So as of now, all cases have been settled, but based on the on what Ericsson had patent arrangements, license arrangements with other device manufacturers, in some of the cases the courts have even decided an interim royalty premium to be paid to Ericsson during the pendency of the case. And but yes, because these are settled, again, FRAN terms have not been scrutinized as yet in India, and that is an open question. Similarly, with the Dolby cases, Dolby joined the foray and sued Chinese mobile manufacturers, Oppo, Vivo, and several other entities, and some of them have settled with Dolby. And so what we see in recent trend is that SCPs are becoming more assertive in India, and these are the cases right now which have come to the court, but there are a lot of negotiations and licensing arrangements that are now happening between device manufacturers and the standard essential patent holders, and negotiated well. And in fact, this has even reduced some kind of these judgments have reduced the future volume. So because now the licensing, obtaining license is becoming a norm. Apart from SCP cases, there has been I'll come back to SCP cases. Is one of the peculiar defense that is taken by the defendants in SCP cases, especially the Ericsson cases, is that the defendants alleged that Ericsson is abusing its dominant position. In a way, they were trying to say that the patent holder is not offering license arrangements on FRAN terms, and in fact abusing its dominant position to corner the defendants on high royalty rates or some other terms which were not very amenable for the defendants or normally under the law. And so they approached the Competition Commission of India against that with this allegation. So CCI found prima facie case of abuse, and it ordered further investigation in those cases. And one important point is that in a suit for infringement, this defense cannot be taken. The antitrust law defense cannot be taken in the suit for infringement. The defendant has to file a separate complaint with CCI in this regard, and it has no bearing on the suit for infringement. So the suit for infringement continues as if there is no complaint filed. On the other hand, the CCI investigates as if there is no suit. So those are mutually separate. I mean, and the proceedings of CCI are in rem. That means that once CCI decides that there has been an abuse of dominant position, it applies to the world in general and not particular to the party who has complained. Whereas a suit for infringement is in personam and it applies to the defendant only. And even in patent cases, there is an option for John Doe orders and Anton Pillar order, in the sense that even the legal principles are common between trademarks and patents as far as interim injunction is concerned. And obviously the 3 pillars of interim injunction, the plaintiff has to establish prima facie case, and the balance of convenience should be in favor of the plaintiff. And if the injunction is not granted, if plaintiff can show that there will be irreparable loss and damage, injury to the plaintiff, then yes, interim injunctions are granted. Apart from SCP cases, there is spurt in pharmaceutical cases as well. And one is Roche versus Cipla, which is a very landmark case. And this has also been decided after a very exhaustive trial procedure. The case even went before the division bench, and then it was finally decided by the division bench. So in this case, the High Court found Cipla to be infringing the Swiss drug manufacturer Roche. Roche's patented drug allotinib hydrochloride. And next is the Merck Sharp and Glenmark case. This case was also decided after a full trial. But what is significant about it is that the ruling was passed in less than 2 years. Now, one of the most cited, I would say, case is in any proceeding is Novartis versus Union of India, although it's not a recent case, it's been time. It's a landmark case on Section 3D of Indian Patent Act that more or less said that prohibited patenting of derivatives of a patent drug unless they show enhanced efficacy, and even qualified it to be enhanced pharmaceutical efficacy. So although this case was more on the patentability aspect, but this is being cited a lot in the infringement proceedings as well. But the nevertheless, the tilt of normally the courts is to grant an interim injunction if there is a prima facie case that in favor of the patentee. Now, these are the other trends that have seen light right now. One is the increased litigation in smaller cities. Not much in patents though, but in smaller cities, there is a lot of litigation going on in design, especially in the Punjab and Haryana area and the southern area. So, in fact, I myself have filed few cases in Punjab Haryana High Court, and I found that the judges or judicial officers are quite well equipped to understand these cases, although they have to you have to make extra efforts to discuss to bring on table the nuances of a particular law, that's a patent or design, but otherwise they're quite equipped to handle IP cases. But most of the cases are being filed in Delhi High Court only, and this is the trend right now, that it's picking up in other states and other high courts, which is a very positive trend, because it would eventually reduce the burden of Delhi High Court and other courts, and spread it and provide sensitization all over the country. And one more important part is grant of punitive damages, and my colleague Umesh has already said that now the high courts are quite liberal in granted punitive damages. So we can divide damages into actual and punitive. Actual is that what the plaintiffs suffer in fact, actually. So that would be rendering of accounts. That's what is happening in the Phillips case that I discussed, that the local commissioner is appointed to render the accounts of for rendering the accounts of defendants. So that is the actual. But apart from that, punitive damages have also been granted, and and especially in trademark cases, well, they are quite high. Then another aspect, which is not more or less infringement or enforcement, but there is an increase in the filings for registration of patents and designs in smaller cities as well. Apart from the litigation enforcement picking up there, it's more, people are becoming more aware about the importance of having IP rights, and this is also quite a positive note. Now, but these are what we have discussed right now are the trends. But apart from that, there are some challenges also right now. And one is that all those steps have been taken by the court and the government to reduce the delay involved in litigation. But given the entire burden of IP litigation focused on few courts only, there is some delay that happens, and earlier it was also witnessed that the rotation of, the roster of judges used to change in the high courts, and it was becoming very difficult now to discuss, to argue. So one judge would hear part arguments and then he would be transferred to another bench. So in that scenario, now there has been quite a lot of reform, and the original site judges are rotated. The roster is managed within those judges only, more or less, and the judge who has heard the part arguments would pass the final order. So there is no need to have new arguments before a new judge. So it's more on the same judge who has heard the part arguments would be finally adjudicating the matter. This is one helpful reform, uh, but still there is a lot of delay that is seen. Uh, it has to be curtailed. Another challenge is that in India, the IP cases are filed or heard by the benches which are also hearing other matters, other civil cases, and which is again clogging the court business. And particularly because the IP issues in patent and design require some technical consideration. So it is necessary to have some specialized IP courts in India that would expedite the enforcement, bring more confidence, and also it would be a lot convenient. Although we have, for invalidation, we have a specialized IPAB against controller decisions, or if we have to revoke a patent and hear appeals from the orders of the controller. So that is a specialized code. And similarly, it's like argued that if we have specialized IP courts, it would be much beneficial for the litigants in India to enforce the IP, their own IP. And then there is the IP sensitization of judicial officers that is required in smaller cities. As I discussed, although they were well equipped, but still they have to be explained the nuances of the particular IP law, like patent or design or trademark. Trademark, I believe, because there's a lot of litigation, so the judicial officers are quite equipped. But as far as patents are concerned and designs, one or two hearings actually, are on the law itself, or what the patent law establishes, what design law establishes, and those case laws have to be discussed, which takes a lot of time in arguing, even at the interim stage. And so if there is more sensitization, that would be quite helpful. That is one of the challenge. And so far, that's all I have. If you have any questions, you can ask me.
Yeah, there are a few questions, Sharma. I have one from Mohit Gulati. He asks, is there any remedy, either civil or criminal, for IP enforcement for which we can approach IPAB?
Okay, so not enforcement per se, but yes, in indirect way, IPAB can be approached for revoking a particular patent. That like if there is an infringement or likelihood that there is some dispute that the patent has not been rightly granted, then yes, the only remedy before IPAB is to go for revocation. Otherwise, infringement suits are filed only before the courts, district courts and above.
Right. Thank you. There's also a question from Ojaswani. She asks, please comment on the use of entire market value versus use of smallest saleable patent practicing unit as a base for calculating royalties.
Yeah. So normally, right now in India, it is more of a use of smallest saleable patent. I mean, the last commodity, that is, like for example, in Ericsson, the royalties were paid on the basis of the value of the handsets. Although there were claims that the chipsets were manufactured by Qualcomm, and Qualcomm should have paid some royalty instead of the final manufacturers, but the courts in India also held, although that has not been adjudicated upon after trial, but at the interim stage, it was held that it should be based on the mobile handsets as base for calculating royalties.
Right. Mr. Lin Lazaro also asks, could you please discuss the enforcement of trade secrets in India? I don't know if you'd like to speak on this, but you're welcome to.
Yeah, that's no problem. So, unlike patent, design, and trademarks and copyrights, there is no statutory law for trade secrets. So, trade secret is not as such recognized. So, it is more of the impetus is more on the holder of that trade secret. So, if it is leaked out or it could be reverse engineered, then there is no remedy as such. But apart from that, if as a contractual agreement for confidentiality, if let's say the leak was because of employees bound by the confidential information, and normally if there are not if it can be shown that it was by fraud or some other, it was a theft of trade secret, then yes, there are remedies available, but as a civil law, under civil law, not any particular statutory law.
Right. There's someone also asking, saying that he agrees with you about IP courts being helpful for patents in India, but do you see they're being introduced in India anytime soon?
No, there is no. I mean, there is no likelihood anytime soon. But yes, the stakeholders are voicing this, and let's see. Even in fact, IPAB was not functional for a long time. Now it is functional after like 3 years or more. So it's not in recent future, but eventually I believe that there would be some specialized IP codes, as in other jurisdiction as well.
So we hope so too, Varun. Well, I don't have any more questions. Varun, thank you so much.
Yeah, I would like to answer Anushri also. Is Anushri there? She had asked some questions.
I'm there. I wrote my question. In fact, I don't know why it was missed. I wrote your experience in the area of plant variety protection if you have for the IP enforcement.
Yeah, I have, but not more than you, I believe. You are quite. Anyways, but yes, there was this PepsiCo case in Ahmedabad court, multiple cases that were filed by PepsiCo against farmers in Gujarat.
Yeah, but that is taken back. It is
yeah,
more...
those are withdrawn. So apart from that, there is no I mean PPVFR enforcement to my knowledge as of now. But certainly I can do some research and find that out. But like on top of my mind, apart from that, there has been no enforcement as such of PPVFR.
Yeah, and what about your experience, the present scenario? What is COVID-19 issue has been happening? As you said, there are a lot of pharma sectors, a lot of infringement suits, and a lot of cases have been coming up, and also in recently, even in June. So, any cases have you come across in this area related to pandemic COVID-19 issue?
Yeah, in fact, both at the High Court level and even at the IPAB level, there was this one case, AstraZeneca versus NATCO, in which the March, sometime before COVID, it was AstraZeneca Pharmacyclics, I guess, Pharmacyclics case against in which the injunction was set aside after the patent of Pharmacyclic was revoked. And now even IPAB heard it through video conferencing, and they have actually put on hold the controller's decision to. So what happened was Pharmacyclic filed a suit for infringement. Injunction was granted. The defendants had opposition. Hello.
I think somebody is speaking between. Yeah, now I can hear.
So what happened was then there was a post-grant opposition going on, and which was allowed. Patent was revoked. Then the patentee again went before IPAB. That was during the lockdown period, this present scenario, and the IPAB heard it over video conferencing, and it stayed the controller's order of revoking the patent as of now. And there are, if you see the cause list, we see the cause list, there are a lot of pharma cases that are coming up, AstraZeneca, and there are other cases that are still being heard. by the courts, and notices are being issued to the defendants, and cases have been fixed for arguments on interim injunction. So the things have not stopped, but the only criteria is that as of now, the plaintiff has to show an urgent requirement to put up the case for hearing. The normal pending cases, regular cases, are not being heard as such through video conferencing, although we expect very soon that it would start as well, now since video conferencing rules are there. But urgent matters, yes, for injunction, they are being heard by the court through video conferencing. Seamlessly, I would say.
Thank you, Varun. It's good to see you and wonderful to hear you too. So have a nice day and stay safe and stay healthy. Thank you.
You too.
Thank you. Would you like to take another question? Although we are running really out of time now. It is from Aman Sinha. What he says is, what is the effect of mandatory compulsory pre-suit mediation on IP cases in the courts? Quickly, if you like.
Yeah, so mandatory is like if you file a suit under Commercial Courts Act, which is all IP cases, there is a mandatory requirement to first go for a mediation. So the effect is, if the mediation succeeds, then the matter ends. The court can finally pass an order on that as well, because you have actually filed the suit. But if it fails, then yes, the court will proceed with the entire stage of trial and pleadings, unless it is settled during the pendency of the case. But in case where there are no urgent relief sought, it is mandatory for the plaintiff parties to go for a pre-institution mediation.
Right. And there's also a quick question, which I think you have already addressed partially, is what in your experience, to what extent do the commercial courts help in addressing the need for specialized IP courts? To what extent?
I mean, as such, there has been no forum in which this has been discussed before the commercial courts on the issue of specialized IP courts. It's more like a governmental decision in that respect. But commercial courts as such, right now, because they are being assisted, they are not very, it's not, the thought process is not proceeding on those lines as such, if we see the commercial court, because more or less they believe there are remedies in the sense that they can go for scientific advisors if there is any technical issue, and obviously technical expert witnesses would be there. And so it's, as I have answered, like, it's not in the recent future, but yes, there is a need. And in fact, a lot of jurisdictions in the world have specialized IP courts, and that has helped in deciding a lot of cases in a very less time.
Right. Okay, Varun, thanks so much. I'm going to now move on to the next session. Thanks so much for that wonderful presentation, followed by your interaction. Thanks very much. Ladies and gentlemen, we are now on to the last session of the day, which is on copyright enforcement in India, current issues and recent trends. And to address this session, we have Ms. Aparajita Nigam, Senior Associate, Lex Orbis. Aparajita's work profile includes trademark, copyright and design matters, domain name complaints, among other areas. She's an avid researcher who has received much appreciation for her publication works, and she's been working on a diverse client portfolio encompassing Fortune 500 companies, MNCs, small and medium-sized enterprises, and technology startups. I'll invite Ms. Nigam for her presentation.
Hi, Dipankar. Thank you for the introduction, and hello to all the participants. Let me just quickly get started. So I'll just launch my PPTs. Just give me a minute. Yeah, I hope the PPTs are visible. Hello?
Yeah, Aparajita, they are. Please go on.
Okay.
Yes.
Thank you, Dipankar. So, yeah, so let's get started with copyrights now. So, The basics. So copyright, we all know, is an exclusive right that is granted to the author, publisher, or the creator of the work, basically, to deal with the work. And copyright is basically a bundle of rights which comes along with a lot of rights like reproduction or storage or issuance of copies to public, or performing the work to public, or communicating the work to public, making translations or making adaptations. The subject matter being literary, artistic, dramatic, and musical works, sound recordings, and cinematograph films. The term of copyright being for literary, artistic, dramatic, and musical, its life of author plus 60 years after his death, and for sound recordings and cinematograph films, it's 60 years from publication. One question that often comes up in copyright practice is that people usually tend to ask that when is this 60 years period start to run? So it is like, I'll give you an example. So if supposedly a film gets published today on June 24, 2020, or supposedly an author dies on June 24, 2020, so the term of copyright will start from the next calendar year, that is January 1st, 2021. The next often asked question is whether registration is mandatory for enforcement or not. Well, there has been sort of a mist around this, but generally and majorly accepted position is that registration is not mandatory, though advisable for the purpose of enforcement, because it creates a prima facie evidence in your hand if you want to enforce your rights, and especially it comes really handy if you want a police action or criminal enforcement. But as such, it is not mandatory for enforcement, and you can go and file a suit for infringement. Now, this comes from language of the Act itself. So if you read, if you compare it with the Trademarks Act and you read Section 18 of the Trademarks Act, it says that any person claiming to be the proprietor can file an application to get a trademark registered. So in Trademarks Act, it is anyone claiming to be the proprietor. So it doesn't assume that the person is proprietor from the very starting. But in Copyright Act, when you read Section 44 and 45, what it says is that any author, publisher, or owner of the copyright, not a claiming owner, but owner of the copyright, can file an application to get the particulars of the work registered and entered in the register. So what it speaks about is a formality of entering the particulars in the register and not for getting the right. Similarly, like you have Section 27 and 28 in Trademarks Act, which talks about the effect of registration, that after registration you acquire so-and-so exclusive right or monopoly over the mark. No corresponding sections are there in copyright which says that after this copyright is granted to you, then you attain a right. No, you have a right since the time you have created a work, it comes automatically. It is only a mere formality of entering that into the register. Now, why this debate comes up or why this mist has been created is because of a few judgments that have been given contrary, which have taken a contrary view and says that it is mandatory. So as you can see in the PPT, the right side, you have a non-mandatory view coming from Calcutta High Court, Madras, Allahabad, Kerala, and Delhi High Court, even from MP High Court. And the mandatory, judgment came in 1969. The very first time it came in 1969, when Madras High Court, in this particular case, Mishra Bandhu Karyalaya, took a view that for enforcement, registration of copyright is mandatory. Similar view was taken by Odisha High Court in 1985. And also by Bombay High Court in 2012. But one thing that has to be kept in mind is that this Madhya Pradesh High Court judgment, which basically started this, has already been overruled by a full bench of Madhya Pradesh High Court. As you can note on the right side of the PPT, in KC Bakoria and others versus Dinesh Chandra Dubey. So the full bench of Madhya Pradesh in 1995 has already overruled that particular judgment, and they also showed a dissent with the Odisha High Court judgment. However, even after that, in 2012, Bombay High Court judgment spoke about this issue, and an SLP was filed against this in Supreme Court, which dismissed the SLP, but Supreme Court said that the question of law remains open. So no final point of law has been laid down by Supreme Court yet. So, but right now the generally acceptable position is that it is not mandatory. However, it is advisable. Moving on to remedies, as we know that we have, civil, criminal, as well as administrative remedies. In civil, you have injunctions, you have interim, permanent, you have damages, accounts of profit, recovery of infringing copies. You have John Doe orders to apply for in case of unknown defendants. You have Anton pillar orders to, enter the defendant's premises and seize goods. Then in criminal, you have imprisonment, fine, search and seizure. You also have administrative remedies for, in the sense that you can give a notice to the Commissioner of Customs or any other officer authorized by the Commissioner in case you apprehend that some sort of, infringing copies may be getting imported into the country. So in that scenario, you can send a notice to the Commissioner of Customs stating that, and giving details about your ownership of the work. And if after proper inquiries, they feel that, yeah, you are the owner and these are the infringing copies, so all those infringing copies will be treated as prohibited goods. One more thing I would like to, address here in remedies, and especially with respect to criminal enforcement, is there has been one more debate surrounding especially criminal enforcement, which is about cognizability of copyright cases. So there has been quite different judgments on this point, whether the copyright infringement, in the sense the criminal offense of copyright infringement, whether it is cognizable or non-cognizable. Now, in that case, what has happened is that if you see the very recent judgments, one was given very recently in November 2019 by the Delhi High Court, which says that it is cognizable. So understand the cognizability, IP, like the Copyright Act, does not give a specific answer to it. So we have to go to CRPC. So in CRPCs, if we see, then Schedule 1 and Part 2 gives the offences which are not given in IPC, but offences given in other acts. And there it differentiates offences into 3 categories. The first category being, offences which are punishable with death, imprisonment for life, or 7 years or more imprisonment. So that is out of question. But the question or the debate is around the fact that whether copyright infringement falls under category 2 or category 3. Now, what category 2 says is that it says that anything where imprisonment is 3 years and above, while category 3 says imprisonment which may extend to 3 years. So one is 3 years and above, and the second is may extend to 3 years. Now, we have to understand where the copyright infringement offense falls. So, in copyright, it is given that, something is, if supposedly in section 63, it is given that the imprisonment has to be like the minimum imprisonment is given 6 months and the maximum is given 3 years and the fine is 2 lakhs. So here, there have been 2 kind of judgments, one coming from Guwahati High Court and the Kerala High Court, which said that it is falling under category 2 because the maximum punishment that one can get is 3 years, and category 2 says 3 years and above. So it should be a cognizable offense because it is falling under category 2. While there has been other pattern of judgments by the Andhra Pradesh High Court, the Delhi High Court, the Rajasthan High Court. From Delhi High Court, there have been actually a number of judgments, one being in 2013 and one being recent in November 2019, which say that no, copyright infringement actually falls under category 3 and it is a non-cognizable offense. Now, where is it coming from? It basically relies on 2 Supreme Court judgments. Both of those judgments aren't really related to copyright cases or IP cases, but the language of imprisonment or the punishment given is very similar to what is given under the Copyright Act. So one of them I'll quote is being Avinash Bhosle versus Union of India, which was related to Customs Act, and where it was given that any punishment which is given as may extend to 3 years is not same as 3 years and above. It says that when you say that may extend to 3 years, it means lesser than 3 years. It does not mean 3 years and above. It is not similar to 3 years and above. And on the basis of this particular judgment, Avinash Bhosle versus Union of India, all the other pattern of judgments have been given, especially by Delhi High Court in 2013. It was stated that because of Avinash Bhosle versus Union of India, which has been passed by Supreme Court, it is to be, the other judgments given by the Guwahati High Court or the Kerala High Court stating that copyright infringement is actually a cognizable offense, they all stand overruled because of Avinash Bhosle versus Union of India. So that was about cognizability. Then moving on to discussing what all technological advancements have actually, created new ways of infringement. So first talking about software piracy. So there are various kinds of software piracies that are happening. One being the counterfeit, that, you copy the software and you also copy documentation as well as, create a complete replica with the complete copy of the packaging as well. The second being you make a copy and into, any kind of media. It's not really a counterfeit, but it's a copy. The third thing is a reseller piracy. What is a reseller piracy is that it happens in the supply chain itself, because of which the supply chain check is very important. So the dealers and the distributors, though they are the authorized dealers and the distributors, but what they do is, for example, they acquire 500 copies authorizedly or legally, but then they make 500 more copies of those, or n number of copies. So this is what is happening, like a piracy happening in the supply chain itself. The other kind of piracy is the bulletin board pirate. So what happens in a bulletin board piracy is that, so there is this one pirate who has acquired software from some unauthorized source and has stored it in his computer system. Now he will give access to that particular software over the internet through a link. So all n number of people wanting to have that software can download it and extract it from that particular software downloaded in the system of that one pirate. The other being end user piracy, where the consumer itself is indulging in piracy. For example, I buy a software and then I make 5 copies of it and sell it among my friends, or give it among my friends. Or supposedly there are at times a restriction given that if you purchase one copy of the software, you can put it in 2 devices, or you can run it on 2 devices. But people at times would want to store it or run it on more than the upper limit of devices that has been allowed. So these are the kind of piracy that are happening in the software industry. Then of course the very infamous piracy of cinematograph films that is happening through counterfeit CDs and DVDs and camcorders. You put a camera on your shirt and you enter a theater and you copy the whole movie, and tomorrow you can just sell it making CDs or DVDs about it. The other thing which has been noticed in a very recent since a few years is social media. You see complete movies uploaded on Facebook, on YouTube. Forget YouTube, even on Facebook you have I've been seeing like the whole movies and very recent movies uploaded on Facebook as well. Then I think the most worst situation comes in online piracy is when movies are leaked even prior to release. So this happened with a lot of movies, Manjha and Udta Punjab being quite infamous ones. And we know that Manjha was a very critically acclaimed movie, but it saw only 10 to 12% occupancy rate when it comes to theaters. So this is the kind of loss that not only the entertainment industry is bearing because of all these, how online piracy has become so easy because of the technological advancements, but it also has a very bad brunt on the Indian economy. Next, all other kind of works. So even in sound recordings and musical works, there are so many websites from where you can download songs so easily. Yeah, I remember even when I was a kid or when I was in school, I don't think so we ever knew what IP is. So as a school kid, even I am responsible for it, because I think all of us must have downloaded a lot of songs because people don't even know what they are doing is wrong or what they are doing is a crime. So it is very easy because of all the technological advancements. It is so easy to download songs and not to really subscribe to the legal ways of accessing the sound recordings of musical work. Then you come to literary works. Then you have ebooks available, in the sense you have PDFs to download. You have audiobooks available. Then recently I have come across a lot of infringing podcasts as well. So this is a very actually recent example. So last month I was listening to a podcast. It was by a new writer who was reciting his poetry. So in episode 1, he recited his own original content. I really liked it. But then from episode 2, he started to recite content written by other authors. So he was reciting Madhushala by Harivansh Rai Bachchan, and not to take away the brilliance of that poetry, but what was going in my head was that he has taken someone else's copyright work and now he is communicating it to public. Now, one thing has to be remembered, that though it is fair use to communicate or to recite reasonable extracts, but when you make a whole podcast series only reciting someone else's copyright work, it cannot be called a reasonable extract, because you have completely communicated the whole work to public. So that is happening through podcasts. Then you have dramatic works as well. These days, scripts and screenplays are getting leaked. We know what happened with GOT season 8. So even in case of dramatic works, it's being leaked. In artistic works, we have, it's very easy to copy any image from Google Images, and people don't even care to see whether it's a copyrighted image or whether it's like a royalty-free image. So that is how it's happening, because it's very easy to just Google an image and, download that image. The other thing which happens is photography. There are certain places where photography is banned. Now, it's banned for a reason. For example, museums, you go to museums, they often ask you to pay a certain fee if you want to, do photography here, because there's a lot of work. There's a lot of copyrighted work which is displayed. So I'll give you an example. In Chandigarh, there is this museum which has very beautiful paper effigies, and if you see that, it's brilliant actually. But then they ask you to pay certain amount if you want to use cameras inside the museum, which people often try to evade. They don't pay, but then they have a camera. They have a camera phone in hand. It's very easy to go around and click an image anytime they want to. So this is how piracy is becoming very rampant, and it's increasing and becoming absolutely ubiquitous in nature because of all the technological advancements. Now we move on to how judiciary has dealt with it. So one most common and sought after remedy is John Doe injunctions, of course. It specifically is very important for say movies and sporting events, any kind of work which basically has a very short shelf life. So supposedly you have broadcasting rights of a particular sporting event, or say if you have a theatrical release coming up, so you have a very short shelf life. Okay, so a movie will be there in theater for say a month or one and a half months or 2 months. A sporting event will go on say for hello.
Please go on.
Yeah. Okay. So like a sporting event can, go on for a month or a month and a half. So because of that short shelf life, at times it is very difficult to, get to know who the real infringers and defendants are, or to know the identities of the defendant at the very first go. So because of that, and there are number of defendants which could be there, number of infringers which could be there. So because of that unknown nature of defendants, we have these John Doe injunctions, which can be used for preemptive enforcement and, against all number of defendants. So how you go about a John Doe injunction is that, how you secure it? Basically, the 3 pillars of any temporary injunction are used in John Doe order as well. And how you plead it? Basically, supposedly, 3 defendants, 3 infringers. So 1, 2, and 3 can be named defendants. From number 4 to whatever number you want, say 50, 60, you can put 4 Ashok Kumar or John Doe, like 4 John Doe, 5 John Doe. So you name all other defendants as John Doe, or in India, it has an Indianized version called Ashok Kumar order. So that is how you'll plead it. In case once all the defendants and are exhausted, you can even implead more John Does at a later stage. In case you think that you have taken action against all of them and you need to put more, then more parties can be impleaded later also. Now, this basically started with the 10 Sports case, where it was the case about the FIFA World Cup 2002, where 10 Sports was having the exclusive broadcasting rights, but the other cable operators unauthorizedly started to transmit the 10 Sports channel. So that is when John Doe started in India. It was there internationally before, but this is the first case in India related to John Doe. And it was affirmed that such orders can be passed till the time the litigating finger we know is pointing towards whom. So even if you cannot identify the exact person, it's a mere misnomer and must not take away plaintiff's remedy in any manner. One of the recent cases last year, it was in ICC Men's World Cup also, because I said, sporting events and movies, John Does are very common in both of these cases. So, so this was also in ICC Men's World Cup. So audio rights for broadcasting was exclusively with Channel 2 Group Corporation, and it had applied for a John Doe order, where John Doe was granted. And one thing that was pointed out by the court here was that no one else can give a live audio broadcast of the sporting event that is happening. However, they can give a broadcast if a 15-minute lag is maintained. This 15-minute lag thing was laid down in Star India Private Limited versus Piyush Agarwal by Delhi High Court, and it was also later affirmed by the Supreme Court in another Star India case. So if a 15-minute lag is being maintained and it is not exact real-time commentary, then it's fine. Otherwise, injunction would apply. And it was also asked it also asked all the search engines to delete any kind of results coming on their pages for any infringing websites. And direction was also issued to the ISPs to block any unlicensed content or any infringing websites. As I said, this is already covered that apart from sporting events, it is also movies, and Bollywood uses John Doe injunctions a lot. So there have been two approaches that has come, while issuing a John Doe injunction or issuing any kind of injunction against websites. So one approach is that blocking access to specific URLs, and the other approach is blocking access to complete website. But now the position has been clarified to a great extent that in case it's a rogue website, and I'll come to it later how we identify a rogue website. So in case it is a rogue website, there would be a complete blockage to access of that website. But in case it's a website which is not a rogue website, but which majorly hosts legal content, for example, say YouTube or say MySpace, but there are certain infringing content also being hosted on that website, then in that case, there would be blocking of specific URL. Yeah, so then we move on to liability of intermediary when it comes to copyright. So in MySpace versus SCIL, which is one of the cases that came in the recent past regarding the liability of intermediary in copyright cases. So here what it was said was because MySpace is not a rogue website, so here it was that specific URLs need to be blocked. Also, intermediary must have actual knowledge of infringement and not just general knowledge. It shouldn't be generally like, I know that I have a website, so certain infringing material could be there. Not that kind of a general knowledge, but an actual knowledge, and that actual knowledge can be given how? By the plaintiff or the future plaintiff or anyone whose rights it's being infringed. They need to send a notice, and they need to send it to actual knowledge of the intermediary. So if in that case, if supposedly the intermediary has received a notice from you and he has received an actual knowledge, then yes, they will have to take it down within, as 36 hours, which is there given in the intermediary guidelines of 2011. And this is how it was in MySpace, and it was also said to SCIL that you have to provide the links of the particular URLs because it's not a rogue website, so particular URLs will have to be blocked. Recently, there has been a case, it I think got decided on 29th May or 30th May, this injunction was passed, interim injunction. It was passed very recently last month. So it was in Dainik Jagran. So what is happening is that Telegram, if their LLC, it has an instant messaging app called Telegram where a lot of people can make their channels, and they sort of keep the identity of the operators of these channels masked, so the identity is not revealed. And what Dainik Jagran noted was that a lot of or digital copies of Dainik Jagran newspaper, like the complete newspaper, were being circulated on these channels. So that is why Telegram was also included as an intermediary, and an injunction suit was filed along with it was for a John Doe order also, because as I said that the operators, identities of that operators of the channels on Telegram, that identity was not disclosed. So A John Doe was also filed for those operators, and Telegram was one of the defendants, and an injunction has been passed, and Telegram was asked to deliver all the details of all these operators within 48 hours of receipt of this injunction order. Then a very new and novel remedy that has come up last year is dynamic injunction. It was there internationally, but in India it has come last year. Seeing the recent one of the cases that happened in Singapore. So here in UTV software, what happened was a case was that at times these rogue websites, what happens is there's a whack-a-mole effect. So what we call as the Hydra-headed defendants. So if you block access to this particular website, blockage happens. Either you block access to the IP, there's an IP blocking, then there is a domain name server blocking, DNS blocking as we call it, or some other kind of blocking. But at times these rogue websites which are blocked, they create a new online location for accessing the same content. So they create a mirror website, or they create a alphanumeric website. So that website is basically, just a little change, just change a little in the domain server or what, and they create another online location. So one website is blocked, but the exact content of that blocked website is available on this other mirror or alphanumeric website, and people can still access it. So to combat this issue, because otherwise blocking a website is becoming, you block a website but the content is still available. So what is the use of it? So because of that, and to avoid the hassles for the plaintiff to again approach the court for the order against this new mirror website or the new alphanumeric website, what has come is that there is a dynamic injunction which is granted, wherein if you have received a particular injunction order and you see a new mirror website or a new alphanumeric website coming up, so then you can just approach the registrar and to get that injunction extended to this mirror website or this alphanumeric website. So you have to approach the registrar, of course, with an application for implement of this new party, which is this new website. And along with that, you have to give an affidavit also stating and verifying that this new website that you are seeking to block is actually a mirror website, or it is actually a alphanumeric version of the already blocked website. So this is one of the very novel and new remedy that has come to combat this mirror or redirected or alphanumeric website issue. And also the court has asked the ministry to explore the possibility of if there can be, because a lot of times we have youngsters who do not even know that what the content that they are accessing is actually an illegal or unauthorized content. So the court also asked the ministry to see if there can be any possibility. So for example, if a youngster or any person for that matter is accessing any kind of infringing content or an unauthorized content, so if a warning could be displayed on the screen that what you're accessing is an illegal or unauthorized content. So they have asked the ministry to explore if something like this is possible. In the same judgment, they've asked this. Now coming to, these were the judicial approaches or the recent trends that have come up. Now we move on to some legislative and administrative measures that have been taken up. So one was a legislative measure taken way back in 2012 about the DRMs, the Digital Rights Management, and Section 65A and 65B were included. A lot of times people ask that where do these 65A, what is the meaning really of this 65A? How do you circumvent effective technological measure, or what do you mean by it? So I'll explain it with an example. So if you take an example of say YouTube. So YouTube helps you watch the videos online. It makes you even download it, not really download it, but save the video to watch it offline later. But you cannot download and save it in your system, not at least through the authorized or legal means. So if supposedly this is an effective technological measure put up by YouTube to avoid infringement. But then there are certain softwares and websites created which help you downloading YouTube videos, or even download them in MP3 as MP3 audios, etc. So this is what is called by 65A as circumventing effective technological measures. So this is one example of it. So apart from DRMs, Then we had draft copyright rules that came up last year. In one of the thing that relates to the digitization is that in Rule 29 and 31, radio and television broadcast has been replaced by each mode of broadcast, which by its language should also cover internet-based broadcasting. But then one of the challenge or conflict that has been created here is that no change or no amendment has been made to Section 31D of the Act. So there may be some kind of conflict being created between the rules and the Act. And also the Bombay High Court in the recent judgment of Tips Industries versus Wink, it said that it should not be including internet-based services. If it says radio and television broadcast, then that section has actually been written for radio and television broadcast. And one of the reasons why Bombay High Court said this was because it said that when you read the complete Copyright Act, there are certain, other provisions which talk about internet broadcasting also. So when legislature was writing this or making this particular draft, they very well knew about internet broadcasting and the internet service providers. So when they knew about it, and there are other provisions talking about internet broadcasting, and 31D not talking about that and specifically writing radio and television broadcast, it means that the intention of legislature was towards radio and television broadcast only and not towards internet-based broadcasting. So this is a kind of a conflict being created. So that has to be sorted, and that is why the draft rules have not yet been notified. It is still a draft. Then the other thing which is coming up is changes in the Cinematograph Act. Cinematograph Amendment Bill was introduced last year. It is still undergoing. It has not been cleared yet, but it is still, in the process. And so it brings on some anti-camcording provisions. Hello? Yeah, so it brings on some anti-camcording provisions. So basically, carrying that camera inside a theater. So it's not, now it is becoming specifically, it is being put in the Cinematograph Act as an offense with imprisonment as well as fine. Then you have, draft e-commerce policy was laid down last year, but now we are coming up with a new policy. So we'll have to see, what are the provisions that comes up in the new draft commerce policy, because just, at the end of last month, DPIIT, it informed that it will be coming up with a new draft. So there were some anti-piracy measures like, identification of rogue websites and and all these rogue websites should be there in the infringing website list so that it can be blocked. So a lot of anti-piracy measures were put up by the draft e-commerce policy, but now we will have to see what the new draft policy has to say. And the prosecution process, which ultimately helps in enforcement, has also been digitized. So in literary, artistic and musical works, everything can happen online. If your work is, below 5 MB, then you don't even need to send physical copies like earlier. And everything can happen online apart from, of course, software, cinematograph films and sound recordings, for which physical copies are still to be sent. And then there are a lot of measures that central and state governments have been taking, like a lot of formation of IPR cells have happened, and the Ministry of Home Affairs has sent its advisory to the state police academies so that IPR is inculcated in their training curriculum. And there are a lot of raids being conducted by state agencies. In fact, MCDCU, which is the Maharashtra Cyber Digital Crime Unit, it has actually recently last year received the award for 2019 Global Intellectual Property Champion Award was received by US Chambers of Commerce. And then a lot of initiatives have been taken up by CPAM, a lot of anti-piracy videos. If you see, like now we are not 2020, but till the last year, if you had visited any theater, especially PVRs, then anti-piracy video campaigns are being run before starting any movie. And there are a lot of things by specifically including IPR in school syllabus, because a lot of online piracy, students and school kids, they are not aware of these things, and that is why this is becoming so rampant and ubiquitous. So, trying to make people understand from the very starting that IP is to be taken seriously and the rights are to be taken seriously. So a lot of programs, awareness programs for school kids, for police officials, trainings for judges and police officials is being done. A toolkit has been prepared for the police. So a lot of initiatives have been taken by CPAM as well. So this is all for today. So we covered judicial measures and the legislative and the administrative measures. And if there are any questions.
Well, yes, there are a few, although the time is really running out. Quickly, if you'll be, one question asks, if there is no compliance by an infringer in a copyright violation and desist the notice, what would be the subsequent remedy available?
Yeah, so see, if supposedly you have sent any CND notice, now it depends on if you're talking about a CND notice or you're talking about a takedown notice. So in case CND would always be sent to like the primary infringer. So if they don't agree with the notice or they don't comply with the notice, then you can go ahead with any of the remedies. You can go ahead with your civil action and you can file a suit for infringement. You can even move on with your criminal remedies, even with intermediaries for like which are we can categorize as secondary infringers. So even in that case, if supposedly you send a takedown notice and there has not been a takedown within 36 hours as provided under the guidelines, then you can include the intermediaries also, because the intermediary in that case has not complied with its liability or its duty of taking down the infringing content. So then you can move ahead with filing a suit in including the specific defendant as well as the intermediary.
Right. Another one asks, adaptation of original work is also copyrightable. Is there any test for determining when an adaptation can or cannot be considered copyrightable? For instance, making similar course materials available online with the same concept, but with a different content. Which category this would fall in?
Okay, see, we have to understand that adaptation, you have to understand what is like an adaptation, what is a derivative work, and what is a transformative work. So adaptation is a part of copyright. If you see section 14, then even translations and adaptations, the sole right vests with the copyright owner. So you cannot make an adaptation of any work. So for example, you are trying to abridge a particular work, like there is a literary work and you want to create an abridgment of it, or for example, there is a literary work and you wish to create a sound recording and a cinematograph film of it. So these are all adaptations. So when you use the word adaptation, then for that you need consent of the copyright owner for that. Even for derivative works, for example, there is this take off. If you know that fan fiction is one of the phenomena, and in fact a lot of novels which have been bestsellers actually started as a fan fiction for another novel. So even in case of derivative works, at times you have to seek, if supposedly that derivative work is a complete derivative work and has not gone into the stage of a transformative work, till that time you have to seek consent of the exact owner of the copyright. But in case you are creating something completely transformative, and where, for example, you have only taken a normal plot from something like, for example, there is a book about three friends, and you create a completely different book about it. You take a mere idea out of it and create it and completely transform it into a different work, then of course you can do so. So you have to understand the difference between all these three, like adaptation, whether what I'm making is an adaptation, a mere derivation, or what I'm doing is a completely transformative work. So if you're completely transforming some work, and how to assess it? Well, firstly, it is very subjective in nature. So it will completely depend upon case-to-case basis. But in case, if supposedly I say that there is this particular movie or this particular book, when I'm creating a movie out of it, and what I've taken is a simple idea. For example, this poor boy falling in love with a rich girl. Now this one concept or this one idea can be made by anyone. Anyone can write a book on it, or anyone can write can make a movie on this. But supposedly, if everything which is in first work is exactly there in the second work. And when I say exactly, that does not mean that it has to be a complete exact copy, but it is substantially and fundamentally there. For example, there is a particular book and there is another book too, and the scenic arrangements and how the events are happening in the first book are exactly how the event, there may be some changes in the dialogues or whatever, but exactly how the scenic arrangements are going in book 2 also, and the flow of book 2 is exactly similar to book 1, then of course, then you cannot call it a transformative work. So, it depends on how much you have taken, how much substantially it is similar to the first work, whatever you have created.
Right. Okay. Then Ajaswani asked, is it possible to obtain a John Doe order for infringement of website design copyright?
Yes. See, for example, any case of unknown defendants, be it any kind of infringement that is happening, you can, of course, go and obtain a John Doe order. That is, if I'm correctly understanding your question, is if any kind of copyright is being infringed or related to any, the content of the website or any kind of artistic work that is present on the website. So, yes, actually in that case, if you have a website, supposedly if you can identify who's operating the website, maybe through a who search, then you can definitely name the defendant. But in case there are some rogue websites, then of course you can go for John Doe.
Right. And on to the last question now. It's getting very extended. Mohit asks that during the pandemic, with physical newspapers on hold and being available in the e-format, downloading and circulating these e-copies or extracting these, would it be a violation of copyrights?
Totally depends on, you cannot circulate it. So this is what I referred to in the Dainik Jagran case as well.
Right.
So, so that was covered there. So what happened in the Dainik Jagran case was that if you go through their terms of use, so you can subscribe, and specifically Dainik Jagran, keeping COVID-19 situation in consideration, what they have done is that, especially in India, it is completely free. So you don't even have to pay anything. You just have to subscribe, but you can read the newspaper only online. You cannot download it. So that is one thing they have put, and that is one of the measures that they have taken. So yes, you cannot download and circulate it. That would not be right. And an injunction was issued in this particular case, which happened just on May 29th. So it depends. You can subscribe and you can read online, but you cannot download unless and until they have themselves provided you the option. So even the download can become an infringing activity, and of course the later circulation of it, which happened in the case. So you will have to see whether what is allowed by the the owner of that, because in Dainik Jagran it wasn't allowed. No download was allowed, and certain so basically there was a circumvention of the effective technological measure, which was under 65A of the Copyright Act. So that is why it is infringement. So it is better to only subscribe and read the paper online.
Right, Aparajita. Thanks so much.
Thank you.
Thank you so much for that very informative presentation on the challenges that the copyright world faces today.
Thank you.
Well, we now have come to the conclusion. In concluding, I'd like to first of all extend our sincere thanks to LexOrbis for partnering FICCI in conducting this webinar. On behalf of FICCI and all the participants today, I also thank the three distinguished speakers, Mr. Puri, Mr. Sharma, and Aparajita, for their insightful and very interactive presentations, as well as to the LexOrbis team members for their support and involvement in organizing this interaction. I also thank Mr. Chawla, Deputy Secretary General FICCI, for his welcome remarks and for his guidance in organizing this webinar. And certainly a big thank you to all the participants for joining us today for this and for your interactions. We hope you found the interactions today informative and interesting. We will definitely keep you informed of our forthcoming IP events and look forward to your continued engagement. Once again, thank you all for your presence and participation. Have a great evening. Thank you. Thank you so much.
Thank you. Thank you, Dipankar. Thank you.